Very good afternoon, everybody. Hello. Good afternoon. Do I have your attention? Thank you very much. Yeah, very good afternoon to you. It's an unusual start time actually for us, 3:30ish. But delighted to see a full room. For those of you who don't know me, I'm Chris Wren, the Executive Director of BritCham's in Indonesia. Delighted to have the opportunity of opening this particular event, which is brought to you by our Technology and Digitalization Hub in partnership annually with Turkish Airlines and our venue partner, Jakarta Land. I recall quite a few years ago, but I do still recall when the UK introduced data protection, and it was a very, very divisive subject. Particularly smaller, medium-sized businesses were grappling not only with the how to comply, but also the implications of non-compliance and also the costs of compliance as well. And it took a number of years actually for the debates to settle, for businesses to get used to, you know, this is the way it is going forward, and everybody's going to have to get used to it. So it really comes as no surprise as Indonesia has discussed this topic for 2 or 3 years and now introduced it to the statutes, so to speak, but there is equally a lot of concern. I wouldn't necessarily say intrepidation, but there's a lot of inquiry as to how the law is to work, what the obligations are likely to be, and the risks for businesses in relation to compliance and non-compliance. So it's with great pleasure that BritCham takes a position on this in terms of socialisation. One thing that we do always say that part of the value proposition of membership of BritCham is an independent flow of business intelligence, of business information, and in addition, the networking platforms that we're able to create while doing that provision of intelligence and information as well. I did mention that Jakarta Land is our venue partner. We're in one of their facilities. World Trade Center 3 is the newest of the World Trade Center buildings. And there is a relatively new gentleman who's here in Jakarta representing Jakarta Land that would like to say a few words to our audience here. If I could invite William Chai, General Manager of PT Jakarta Land, to give a few opening remarks and his own welcome.
Thank you, Chris. Thank you for the warm welcome. As Chris mentioned, I'm the new manager for Jakarta Land. I'm not new to Indonesia. Been here for 5 years and counting. I work for Jardines actually, so you might have seen or met some of my colleagues over the years. So welcome to World Trade Center. This place has been here for a long time, 50 years and counting. So WTC3 is our newest building, and recently I think been new, but I must say things have picked up. I think we're getting a lot more inquiries, especially firms from China. The office inquiries has been picking up, so I think that's a good sign. But without going to bore you with details, I look forward to meeting all of you over the course of BritCham and future events. So thank you for the warm introduction.
Thank you very much. Well, with an anchor tenant like BritCham, of course they're getting lots of inquiries. What do you expect, right? Thanks very much, William. It's a pleasure to be a tenant here. We've been here for, well, I've been here for 16 years with BritCham. We've been all that time and several years before that. And it's been a very, very happy relationship. And I know we also have a couple of colleagues from BritCham that are also tenants here, a couple of floors below us as well. So it remains, even after 50 years, remains one of those iconic locations where trade departments of various nations and their embassies and so on do like to situate. Okay, our moderator today is a gentleman called Chandra. Chandra is lead of strategic initiatives for the FMCG and long tail categories at Tokopedia. He's also co-chair of BritCham's Technology and Digitalization Hub. As strategic initiatives lead at Tokopedia, Indonesia's top e-commerce platform, Chandra utilizes global retail and e-commerce expertise to boost growth and efficiency in the grocery segment, a key area for the company. He leads cross-functional teams in launching new product features, optimizing supply chains, and improving the customer experience. Chandra has delivered multiple successful initiatives, driving cost savings, revenue growth, and improved margins. He's passionate about leveraging a global perspective and e-commerce skills for sustainable growth. He remains committed to achieving his business objectives, and his engagement with BritCham is part and parcel of his personal and professional development. I'm going to hand over the baton now to Chandra as a very, very capable moderator to introduce also our speakers, whom I would like to thank as well, and to take you through today's proceedings. Chandra.
Hi, good afternoon everybody. How's everybody doing? Thank you for coming here today. This is something that I personally am very excited to have discussions with very much subject matter experts from different industries, personal data privacy, right? Working in a technology company, especially one that is under scrutiny by the US, Tokopedia has been bought by ByteDance recently. This is definitely a key topic that concerns us very much. I hope that your excitement to be here and to learn a bit of new things on how we can expect personal data privacy to be seen in Indonesia is just as much as I am excited to find out more from the amazing panelists that we have here today. If I were to briefly introduce the panelists that have joined us today, I'd like to welcome first Bapak Fetri Miftah. Am I saying that name correctly? Perfect. Pak Fetri comes from PT Synesis. He has about 25 years of experience. PT Synesis is an international cybersecurity company that's been operating since 2005. So, with your expertise, I really hope that we can unveil some of the things that I believe our audience is very curious about privacy and personal data privacy as well. The second panelist that we have today is Mr. Mintun from Bumi Varta Technology. BVT has 20 years of experience in the industries of ICT, oil and gas, energy, and sustainable sectors. And with Mr. Min's expertise, we really hope to look at personal data privacy, I guess, from the angle of your expertise. And last but definitely not least, we have Pak Nico, who has joined us. He is a partner at the law firm SSEK. Would really be great to have some of your legal perspective. I think would be very useful to people who are very curious on the implementation stages and things that we can mitigate on the implementation of this law and regulation, and how businesses from small to large can prepare for it. Without further ado, I'd like to welcome the panelists to join us on the stage, if that's okay. Great, yeah. Let's get cozy. Let me pass the mic to you just a moment. Okay. So gentlemen, thank you so much for joining us here today. I think personal data privacy has definitely been a topic that is at the very front and center of global discussions, especially when it comes to industries where I work in technology, right? And this applies, like Chris mentioned earlier on, not just to big companies like Tokopedia, ByteDance, and so on, but also to SMEs who are utilizing the power of technology to expand their business, which is becoming a trend that is increasingly prevalent in the Indonesian economy with MSMEs. The PDP itself, as we know, has been ratified since 2022, but I believe it's still in the stages of implementation and activation at this very moment. So, just for the audience here, maybe I could pass to Pak Fetri first. What do you think, if you were to look into the PDP law that was ratified in 2022, what do you think are some of the key features, and perhaps could you also highlight some of the key similarities and differences that we can see with Indonesian law and other laws that it is probably and perhaps inspired by, like the GDPR?
Okay, thank you. It's interesting that Indonesia had formally referenced GDPR ever since the Undang-Undang PDP was first drafted. But unfortunately, it went through a long period of development, discussion, and some of the implementation aspects of GDPR have not been fully understood by the team that was tasked with drafting the regulation. So when the Undang-Undang PDP was finally enacted, there are a number of implementation issues that have not been identified or have not been understood during the development of the Act itself. And they are now trying to resolve those issues through the government regulation, the Rancangan Peraturan Pemerintah. Now, the Rancangan Peraturan Pemerintah, the government regulation, is now running over 200-something articles. So you can imagine having to understand what's written in Undang-Undang PDP and the 200+ articles that will be part of the government regulation afterwards. Now, also bear in mind that within the Act itself, sector regulators, i.e. financial, health, administration, government administration, is also authorized to then establish their own point of view on privacy implementation. So, for example, even if the Undang-Undang PDP and the government regulation had already defined certain issues related to privacy enforcement, for instance, then if we take into account some of the strategic government initiatives, satu data, one data being established, for example, to exchange information across all the health facilities, then some of interpreted in a different way when talking about, and for sure that we are quite aware that some of the technical implementation aspect of this One Data project is basically not in line with the Undang-Undang PDP. So things like consent management, things like having the subject data having the rights to demand information on what the data is being used for, who it is being transferred to, who it is being exchanged with, and then what other technically related processing that have been done on the data, analytics. So what we see now, the main problem, even after the government regulation has been established, is how the government will actually implement a strategy, near-term, long-term strategy, not only establishing the regulatory agency that will be authorized to pursue any incident or any court cases, but more importantly, how the government will implement a strategy to start enforcing some of the sanctions, some of the criminal clauses that are already written inside that Undang-Undang itself. Now, it's not a matter of the strategy itself, but most of you have been in Indonesia for some time, so you're familiar with the way our government works. So establishing the agency is not a matter of securing funding, agreeing on the structure of the agency itself. There have been studies on how to go about establishing this new agency, the number of departments, what sort of processes that the agency has to have in place. But more importantly, within the first 3 years after the Act has been fully actively implemented, what are the goals of the government? Whether they have an investigation court in place, whether they will pursue any breaches of private information, how to go about implementing the sanctions, the fines. There is also a lot of discussion with various industry sectors, for instance, on agreeing the formula to calculate the fines that can be imposed on an organization that later on be deemed as being complacent with implementing privacy controls. So these are the type of things that are in discussion, and at the moment, my main recommendation for all of you, companies that's now looking at the non-PDP and the draft government regulation, is not only to look at GDPR, but also to look at it from the point of view when we first have the Electronic Information Transaction Act. The initial objective of that act is to limit the number of cyber security incidents. But if you look at the court cases now used in the media, it's mainly used to go after people like, in social media and so on. And hopefully the Privacy Act will not be used in the same manner as the Transaction Act. So my message is to understand the point of view of the Indonesian government looking at privacy. And we're all aware that the number of incidents that have been reported over the last 4 months in 2024, some of the big names are involved in those incidents. And then the fact that there are no clear reports, publicly available reports, on what the government actually did after the incident had died down. There was no publication of reports, for instance, forensics, what actually happened, and then what was the government's stance on the organization, the company that was impacted by it, and more importantly, what the government will be doing to the general public. Information has been exposed during this incident. So my message again is to look at the Undang-Undang PDP from the Indonesian government point of view, and perhaps learn from past cases what the Indonesian government had done on other related Undang-Undang, and then perhaps we can look at where they will be going in the next 3 years.
Thank you, Pak Fetri. So 2 key learnings that I got from there. Number 1, beware the diversity of interpretation of the established law. And number 2, also be mindful of the implementation stages and how that will be embodied, seeing the historical behavior of the Indonesian regulators and government. I guess I'd like to just quickly jump into Mr. Min. Your company deals with a lot of clients who probably will find this implementation of PDP very relevant and very something that they definitely have to deal with and mitigate. What are some of the things that, from what Pak Fetri has said, do you think would be on the top list of priorities of what your clients would be most concerned about in the process of mitigating this PDP law?
Good afternoon. Thank you for coming. I echo, and whatever Pak Fetri just say is, I resonate with all of that. To that effect, we actually took the initiative before the law was enforced to basically re-architecture our entire end-to-end system. But I wouldn't want to talk about PDP as just a PDP, because PDP is just a small part of cybersecurity, right? And there are a lot of nuances that we need to get through. So our company, Bumivata Technology, we have, I'm not sure, maybe 16 million, 17 million data points. But none of the data points are sensitive. Right? So the likes of Tokopedia, for example, Janji Jiwa, anyone who collects name, telephone number, age, gender, etc., they are actually more exposed. Well, although we are a big data company, we actually don't have sensitive information. And when we do come across situation or projects where we need to access sensitive information, for example, FSR, we actually don't onboard the data. We recite our technology behind the firewall, and then we develop API to access our data set to be processed in conjunction with our client's data. So that way we mitigate pretty much all of our obligations and exposure, right? So that's our unique situation. But Indonesia, in the last, I've been here 15 months, 16 months, we see lots and lots of text coming up, a lot of coffee shops, whatever, right? What I get worried every day is these coffee shops, they label themselves as a technology company because the valuation of the company is much higher. But effectively, all they're doing is selling coffee, right? And that's okay. But what's not okay is they don't understand the whole process of I am collecting customers' data, right? But there's a little bit of a barrier there for the hackers is because the data actually sit on whether or not it's Huawei or Google or there's a level of protection. But the coffee shop themselves who are developing these applications are done the likely have, right? And the game, yeah. We can be prepared, the last 30, 40 years, we've been locking down the house, put padlocks, fences, cyber alarm, CCTV. Security is already, but the burglars still get in, right? It's the same thing. We can only react to what's being hacked or what's being attacked. Yeah, we can prepare in multiple ways, but we have to accept and understand that we are going to get attacked by mindset change. So what we do in terms of implementation, echoing what Petri said, the regulation minefield, and my other day job, my other job is the same as Chandra. I volunteer with BritCham's and I chair the ICTIP Infocom and Intellectual Property Act working group. So we're in the constant advocacy work, talking to the MIC and Cominfo and all the kind of people. It is, you ask them a question, there is no clear answer. So the way we've developed is to basically adopt both BDP and GDPR and then curate to what we would need in terms of Indonesian context and reading at what we can understand, what we can extract out of the law, and then we develop. We've also done in terms of development and implementing the whole roadmap is we classed what we can allow to be breached. I'm not a pessimist, but you have to accept that we are going to get attacked. At some point, we are going to get breached. So we have to layer our infrastructure, whether or not it is software, front end, middleware, or back end, right? So it's a bit like a car, right? When you have crumple zones in the car, right? So when the car gets into collision, your bumper gets crumpled, your back end of the car gets crumpled, but the cabin is safe. So it's similar to that sort of process. So we will, overprotect what we can't allow to be compromised. So at least we know we're not going to be, we're not going to be stopped and business continuity. So that's how we developed it, and it's an ongoing thing, right? It's never going to stop. It's where the problem is, like, remember, when we used to go to amusement park, that little thing that pops up, and then you try to hammer it, another one pops up. Well,
Whack-a-mole.
Yeah, whack-a-mole, that's it, right? Well, that is effectively cybersecurity. Because you get attacked, you fix that, by the time you finish, or not even, there's already another one waiting, right? So, yeah, that's the way it goes. And Indonesia having 280 million people, and there is a lot of data to be extracted, right? And that just from consumer perspective. Then you got bad actor from the states. Then you've got industrial espionage. So I'm not going to go into those things, but So there is consumer, and there is corporations, and then there is state-sponsored stuff. So we'll leave that one to the legal person. So yeah, so my point is, number one, accept that we will be compromised. Number two, prepare for that. And then layer your architecture to allow some level of, I'm not saying don't prepare for it, but whatever you do, you are still going to be compromised. So having that mindset at the background, do what we can do to the best of what we can do, and then harden our infrastructure, architecture, wherever we can, and maybe we will overprotect some of the assets. Some of them maybe we don't need to. That goes back to your security philosophy, policy, and how to implement, and based on the tools which are available in Indonesia. So yeah, accept that we will be compromised, and to tier what we cannot let breach.
Yeah, I really like that point actually, where essentially, you know, to be proactive, you also have to realize that cybersecurity as an area is a very reactive segment of running a business, right? It's a risk that we need to mitigate and need to be proactive about it. But the first step is actually to recognize that part of being proactive is to be ready to react.
Yeah.
That's a really good point, and actually a good segue, you know, to Pat Nico, who is very much a legal expert, a partner at SSEK. You know, for the attendees here who are either managers, business owners, whether affiliated with local companies or foreign companies, you know, from a legal perspective, what are some of the key things that that you think they could prepare and start thinking about while this PDP rule is being implemented at the moment?
Yes, thank you, Pak Chandra. First and foremost, good evening, everyone. It's a pleasure to be here. Thank you for your time and attention. I think before I go into that, I'd like to offer a counter proposition, if I can.
Absolutely.
You know, the panelists, Pak Fetri and Pak Min, suggested that the lack of clear regulation is actually a problem for the business community. And a counter proposition to that would be actually, according to some perspectives, actually a lack of regulation is beneficial. Right? Because when we're talking about legal rules and regulation, we're talking about risks and liabilities. And there are no rules, and there are no risks or liabilities, right? So that's one perspective that is an interesting thought that I thought is interesting. Now, to your point, Pak Chandra, I have to highlight that the PDP law was issued in October 2022. There is a transitional period or a grace period before the law is formally implemented, and that grace period is 2 years. The 2-year ends this October. So formally speaking, as of October, you really have to pay attention to the PDP law and start implementing it. Otherwise, there might be risks and liabilities. But I would also add that there are implementing regulations that have not been issued. And some of these rules revolve around whether or not those regulations, those implementing regulations, have been issued. And if those implementing regulations are not issued, there is a lack of certainty. And there's a question as to how those rules will be enforced by the authorities. So that's I think that the panelists have noted that we should be on the lookout. This should be kept in view. Now, on the key points about the PDP law, essentially, there are detailed rights and obligations of data subjects, i.e., individuals, your customers and the people who owns the data, right? To whom the data is attached. So there are detailed rights that are afforded under the PDP law. There are also obligations, more detailed obligations that apply to what is called data controllers, namely companies that manages the data, that collects the data. There are also obligations pertaining to data processors, namely companies that process the data. Okay? So the PDPO sets out these various rights and obligations pertaining to these different parties. One key requirement that is introduced in the PDP law is the appointment of what is called a DPO, or a data protection officer. And this is equivalent, akin to what I call a legal compliance officer in multinational companies. Typically, MNCs would have a compliance department that is headed by a compliance head that reports directly to the president, director, or CEO, the head of the company. Now, the DPO is equivalent to that. Essentially, the DPO will oversee the data policies that a company implements, advises the company to avoid, mitigate data breaches and whatnot. So that is one requirement that I think also affects how companies would operate going forward. So let me just pause there, so I don't have to go on and on, but Sandra.
That's very thorough. So from a legal perspective, I guess it's good to highlight that the obligation and liabilities and responsibilities don't only lie to operating companies such as Tokopedia or BBT, but also to those who handle data processors, data storage. So, you know, for companies that perhaps haven't really had the extent or the experience dealing with the issue of data privacy to begin with, where do you think is the best place to start, in your opinion? Because again, data privacy is a very complex subject, right? As you just mentioned, many stakeholders are involved. What would be, you know, the best first step, the best first thing that they could be doing and thinking about, whilst we have 4 to 5 months until supposed implementation? And you know, Paniko and everybody else, the other two panelists, if you'd like to input on this.
Yeah. The key one, I would say, is to appoint a DPO, a data protection officer. A data protection officer, in practice and in law, typically is certified. So it is an expert. He or she is an expert. And so that person will advise how to manage the data, and advise how to handle data privacy matters and avoid and mitigate data breaches. So I would start with that, Pachandra. Another thing is, and some of the basic things that people often overlook is to have those facilities and infrastructure, basic infrastructure in place, so that data privacy is managed in a legal manner. And what I mean by that is, and typically this gets overlooked, is the consent form. Companies, before you can manage or collect personal data of individuals, you have to secure the consent of that individual. And there are requirements that go to the consent. And again, this is one of the requirements that get often overlooked because it's so obvious, right? It's so basic. But there are essentially 3 requirements here. The first one is that it has to be express. Consent has to be explicit, it has to be clear. It cannot be implied, right? Second, it has to be clear in scope, right? So it goes to what kind of processing will go into managing the personal data. For example, are you only storing it? Are you collecting it? Will you be transferring it? And those type of activities will have to be clearly detailed in the consent. And so the data subjects will have to consent to data being managed in that way. And the third requirement is that it has to be Indonesian. The consent form must be provided in the Indonesian language. There is a fundamental, I'm sure you all know, you've been here in Indonesia for some time, I imagine. So there is a mandatory local language requirement that must be complied with. So yeah, let me pause there, Pachandra.
Well, so consent is actually something that I guess as a consumer, you see it as something, it's a tick box at the end of a registration form. But actually there's a lot of components that comes into it. This is what I also, I guess, discovered throughout my career at Tokopedia, where we deal with a lot of personal and identifiable data of our consumers. We work with legal, Actually, I would like to segue back into Perfect Tree. You know, Nico mentioned that hiring an BPO could probably be one of the first steps that would make sense for a company who's starting to think about the implementation and mitigating risks. The role of data protection officer, I think even in a global scope, is still very much a niche career. What do you think is going to be, do you think human capital is going to be an issue in Indonesia for some of the bigger but also medium-sized companies in finding this talent?
About 2 years ago, we were asked by the Minister of Infocom to conduct a little study on analyzing and identifying the number of DPOs that will be required in Indonesia after the PDBF has been enacted. And we came up with numbers around tens of thousands of DPOs. This is those DPOs that come from legal background, as well as DPOs that need to have more technical background because of the extent of digitalization that is in place in Indonesia. So not only the DPO have to understand the legal issues related to PDBF itself, but also how to understanding how the private information being processed through technology. I'm sure you've heard about the AI aspect of processing private information, right? So we ended up with the recommendation that companies must look at the DPO not as a single person, but as a unit, as a department, whether it's a centralized or decentralized hybrid. And based on that analysis, we also try to identify the level of competency that the DPO must have. So we also help the ministry to write the National Work Competency Standard, SKKND, that have been established about 3 months ago, I believe. And we also developed the curriculum for the Ministry of, not the Ministry, Agency for Certified Professionals to start delivering the fundamental or basic courses so that someone can start to understand having the role of a DPO. Now, the comment that we need to identify DPO, unfortunately, is going to be a tough challenge because we did a quick analysis on how many qualified DPO there are in Indonesia at the moment. Okay, it's less than 100. And based on the fact that we counted the number of people in LinkedIn, yeah, with the certification, the number of people who passed the international certification program that we run in partnership with IIPP. And also, we look at some of the multinational companies that already imported some of the DPOs from their regional offices, even though the current regulations stated that they need to be in Indonesia. So, what we came up with is recommendation that the Minister of Infocom is to fast track the delivery of publicly accessed, publicly available training courses, where the material can be shared with all of the training centers. So basically, Ministry of Infocom has recommended to release the IPR of the content of the curriculum itself. So all of the training centers across Indonesia can start offering and delivering DPO courses to the general public. And even then, when we calculated the number of DPO and the number of courses that can be run by all of the training centers across Indonesia, the government is looking at 3 to 5 year plan and being able to meet the demand of DPOs. So what happens if you can't find a DPO in the job market? Because countries like Singapore, Malaysia, Philippines are also looking for DPOs in Indonesia, and we get calls on a daily basis. Well, there is a thing, the regulation actually allow companies to provide, to offer services, DPO as a service. Basically, you obtain a service from a company that will provide you DPO services. We'll help you write ROPA, records of processing activities, develop your own DPA, assess how well the level of compliance that you have in the organization, look at the technology that you use in processing the information, identifying the third parties that you deal with on a daily basis, whether the private information being exchanged actually covered in your existing contracts with them, you know, whether it's your controller, processor, joint controller, joint processor, or anything, because there's a difference in, there are different issues that need to be covered in your contractual agreement. Based on that, the company will then have to negotiate in renegotiating the contract, because there might be some additional investment involved in terms of putting in encryption technology technology, for instance, to master information, or things like developing a process, automated process, not only to identify the private information, but also to respond for requests from the general public that might ask the company question, what are you doing with my private information? Who have you sent my private information to? And how long are you going to keep my private information? Things like that needs to be responded 3 times 24 hours, so 72 hours response time. You don't necessarily have to answer everything in 72 hours, but at least you're responding to their question, you are responding to their request. Now, developing processes like this might be new things for some of the smaller and medium companies in Indonesia. The bigger companies can obviously start hiring the big names to help them implement that privacy framework. But some of the medium companies, they're still trying to see whether they actually need to appoint a DPO, because there is the act itself said that if you are dealing with sensitive information, health information and so on, or private information in large volumes, they don't exactly say what large volume is, 1,000, 5,000, then you need to appoint a DPO. But the government is not going to issue a registration scheme. But what the government will do, if the company just happened to be involved in an incident, data breach incident, and then the company is found to be negligent in appointing a DPO, even though it was later found that the company is dealing with large volume information, especially as sensitive information as well, then the level of fines imposed on that company would be higher. I explained earlier there's a formula to calculate the fine. There are various parameters we use in the formula, and one of the parameters is on complacency. So there are, it's like a chicken and egg thing. I don't have a DPO, so where do I go about starting it? I believe the government is trying to now to involve some of the universities, legal faculties, law faculties, to start helping companies to understand how to go about implementing the basic or minimum level of readiness, i.e. they have all the documents required by the undang-undang, by the act itself. That's the minimum level of compliance that we recommend the ministry to publicize. Whether they need then, whether they then have to have a measurement scheme in order to be able to say, the level of compliance they have across all of the organization, all of the product and services, across all of their third-party partners. That's something that I said earlier, it's something that the government needs to establish as part of the implementation strategy in a 3-5 years time. So that's
Thank you, Pak. I just want to quickly go back to Pak Nico for a second. So, as a partner in a law firm, I'm sure you're very familiar with, let's say, how dynamic the government is when it comes to managing the regulations, adding new ones, and to be fair, as an effort to also adapt to the new world with Web3, personal data privacy being a recent and prevalent issue as well for average consumers and everybody. But from a business perspective, how do you think, I guess, first from a regulatory perspective, how do you think the PDP law is going to evolve over time, perhaps in the foreseeable future in Indonesia? And given that it's very new, what can we expect for, what changes, I guess, can we expect with the PDP law in the next 2 to 3 years? And a sub-question to that, how can businesses, when they're already prepared for the PDP law that's already being implemented in October, how can they now start to prepare for the potential changes that are about to come in 3 or 5 years' time with the PDP law itself?
Yeah. So in terms of what to expect, what the expectation is, there really is increased regulation and increased enforcement. At the moment, there's really no enforcement, or there is a lack of enforcement. You see data breaches, incidents happening with increased frequency in the last few years, but rarely, and I think Pak Petri mentioned this, rarely do you see any liabilities, any significant liabilities or responsibilities that the company had to incur. right? Because there's a lack of regulation. Essentially, there's no sanctions, at least reported sanctions, right? And so when in the upcoming years, if the implementing regulations are issued by the government, and if they are detailed, and if they come out regulating things that we expect them to be regulated, then you would see increased enforcement. Now, one area is sanctions, as I mentioned. The PDP law actually, interestingly enough, it says that there is a cap of a percentage of fines that a company can be liable for if the company violates the PDP law, and that is currently capped at 2%. 2% of the annual income or revenue of the company, annual gross revenue of the company. So that obviously would affect or regulate how company behaves going forward. And I think this is one area that the regulation seeks to achieve, is to regulate companies' behaviors going forward. And so those are one among the things that we expect to see going forward, Chandra.
So not to be complacent with the non-accountability culture with personal data privacy.
Exactly, yes. So because they're significant, 2% of gross sales or gross revenues, it's significant, especially for the MSEs. Right? And so yes.
Great. So implementation, that's why it's becoming more important for people to actually start thinking about it. Would you say, I think it's quite obvious that bigger companies who would be the usual suspect and targets should definitely prepare for this. One of the steps is consent, hiring a DPO, and reassessing their data infrastructure. But for SMEs, what do you think they could do? Businesses who perhaps don't really have the budget to hire a DPO, and perhaps also have limited talent to take over a quasi role on that part. Besides the consent form, do you have any other, insight that SMEs could implement to mitigate for this?
I suppose one area, and Pafeto is right, in regards to the data protection officer, the DPO appointment. The regulation actually provides that it applies to companies that manages data on a public and on a large scale. So there is some room maybe to argue that this doesn't apply to MSEs, right? But the problem with the regulation, it doesn't actually say that. So there's always that risk of interpretation. You get caught under the regs. So to mitigate any regulatory risks, you should prepare accordingly, right? Now for MSEs, if hiring a DPO is not possible or is not commercially feasible, then perhaps I would say the company should appoint a third party that manages the data. If the MSE is collecting personal data, okay? Or the alternative would be not to manage any data at all, which it is impossible, right? So I suppose that may be one potential, solution.
So although they're not, it's unclear and less likely that SMEs are going to be the target of the, enforcement of this regulation. I guess the underlying note here is it wouldn't be disadvantageous to also still take the precautionary steps to see where the weak points are and see alternatives, hiring a third party to manage or looking to store your data elsewhere.
Yeah, that's it.
Great. Going back to Mr. Min, you did mention that some of the, going back to your point that to be proactive, you need to also recognize that cybersecurity is a reactive area. And I really like your analogy on, in a car crash, your car is totaled, but the cabin should be safe, right? Do you have any specific, perhaps, cases where, it could really be a learning point for everybody here today on how they could, react to this PDP law that's going to be implemented soon?
Well, touch wood, we haven't had any incidents yet. But we have statistics. We run background tools, risk assessments. Even our website is, I think, in the last quarter, something like 50,000 times being attacked. I mean, we're nobody, right? You know, the TPO, TPA and all that is actually not very new. I mean, they've been around for 15, 20 years now. Because PDP, GDPR is not really a new thing. It's been around in America, it's been around in Europe. And even in Indonesia, it might not have been regulated as of now, but if you look at FSI, for you to be on SWIFT network or TT network, whatever network, financial transfer network, you've got to have compliance that is set up by US or EU or whatever, right? Because every single US dollar transferred has to go to America and then come back or continue on to wherever they need to go to. So it's not new. It's always been there, but it's new in commercial or non-FSI perspective, right? And also in healthcare, it's been around for, yeah, like I said, a couple of decades. But coming back to Indonesian context, one of the worrying things that I personally have is the ability of the enforcers, i.e. the government, to be able to objectively assess a situation and pass judgment, so to say, right? And that's one area I have concern. I'm sure it will develop and grow. But having said that, one of the areas that, I just give you guys a quick example. One of the areas that Indonesia has a lot of problem with the intellectual property law, right? With the use of AI, and security, cybersecurity, PDP, you are going to start infringing on a lot of the intellectual property space as well. There are use cases, or there are not use cases, there are examples. Nokia, Siemens, in the past 12 months, if you can go and look at it. There have been IP cases which were launched, and Nokia, Siemens, they won it in Singapore, Malaysia, Hong Kong, Japan, etc. But in Indonesia, they lost, right? And not only do they lose, the judicial system is incapable to handle intellectual property case. And intellectual property is not something new. It's been around for 100 years, right? It's there. But in Indonesia, it is handled by civil court. So that, you know, using that, I'm not suggesting that the cybersecurity is going to be handled that way, but something like intellectual property case, one would have thought it will be in place by now, right? You know, it's not a new thing, but it hasn't been. So the question is, then, is that right? And then, like one of you said about supply chain, because we don't operate alone in the business, right? So I can be as secure as I can be, but he's going to send me an email, I'm going to send you an email. You know, we've been told, don't click, don't open, don't plug in. So one of the key areas is to basically develop human asset, social engineering, so to say, right? And that is one of the key areas that we really need to look into. And yeah, hopefully the government will support us. But the thing is, from now until government gets the act together, if there is a breach, are we able to trust their judgment? And what is the legal or financial or sanction, what's the exposure of that? And that is something, I guess, you guys probably will help us out with.
Well, being mindful of time, I do have one last question, which is addressed to all of you gentlemen. I think one of the key, of course, we cannot avoid the discussion on the government's role in not just creating the act, but also their efforts and infrastructure that's going to be built to enforce the act itself. But for the audience here today, perhaps what are, in your view, some of the misconceptions about compliance timeline and enforcement? I know we have a deadline for October 2024. But yeah, are there any misconceptions about implementation timelines that we, businesses in particular, need to be aware about in regards to the PDP law? Anyone like to start?
Okay. Compliance timeline. You know, honestly, and I think, I mean, hit it right in the head, right? The expectation is 2 years. The law actually mandates that it is implemented in 2 years' time. But you know, as with everything, you know, I was actually just been informed that the implementing regulation to the PDP law is still under discussions. And the implementing regulation is fundamental for the government to enforce the PDP law itself. So if the government doesn't have a implementing regulation, how does it imagine it being enforced? How can it enforce it? There's no implementing regulation. And as it is with Indonesia, I hate to admit that expect delays, right? Don't be prepared for it, but I suppose expect delays, right? But they do have an ambitious timeline. I would say they are targeting the implementing regulation to be issued in July. That was their initial target. But it's May. In 2 months, can they complete the discussions and have it issued? I am pessimistic, I have to say, but I don't know, maybe it can happen. You know, we are transitioning into a new government, and maybe there is some political will there. Another thing is, the law also mandates the establishment of a data protection agency. And this is a state-owned agency that is established by the president. So it reports to the president directly. And so that authority will be enforcing the PDP law. But you know, if there's no agency, who's going to enforce it, right? So there's one of the lacuna or lack of you know, legal certainty that we're currently facing. And so yeah, let me pause there, Achandra.
Any other thoughts from?
Okay, misconceptions. There are 2 articles in the current act that is already, in fact, basically unlawfully obtaining private information and selling those information. And interestingly enough, we had a discussion with the Attorney's Office and what their understanding would be in terms of how do you see someone selling information and getting a financial advantage from selling that information. And what's worrying is their point of view. If you are involved in exchange of information, normal exchange of information, and one of the parties receive information and can take advantage financially from that information, they see it as in breach of that particular article. So they don't, you know, it's different than someone publishing information in the dark web and selling the information for some money. But the fact that you are getting an advantage commercially, financially, from receiving that information, they will see you as being in receipt and selling that information. So we have to spend time explaining to the Attorney's Office that's not what the law was meant to be. Okay? But at the moment, it's difficult to change the mindset because, like I said, the regulating implementation regulators on innovation. And the other issue is that I said earlier that some of the sectors, like the financial services sector, OGK, have already implemented a lot of regulation. One example is that if you go to a bank, unless the bank has a electronic eKYC system connected to Chapel to use biometric to identify themselves, they are still required to obtain a copy of identity card. Okay? And the actual wording of the regulation is obtain a copy of the person's identity card. But if you look at the KTP, there is your religion and your blood type written on the KTP. which has nothing to do with the services being offered by the bank. Unless the bank will send you like a card, wishes card, when you're Hari Raya or Christmas, right? They have no business knowing what your religion is. Okay? And because of this, I tried talking to the bank. Do you know that you have to start going through all your records and somehow deleting or putting black ink across all the religion and blood type? That's not going to happen. You can use AI, you can go to the AI and go through all the databases. No, but the article in the PDP law specifically says that if that happens, you're in breach of that particular article. So that's the kind of thing that the government has to deal with when they start implementing the PDP Act. They have to specifically state in the implementing regulation what happens if there are two regulations, one established by the OJK, one from the Initial Eco-Comp. That's not in line with each other.
Yeah, sorry, I just wanted to add, I actually forgot to address the key question about misconceptions. Let me just address that very, very briefly. There are some misconceptions, I think, that goes around in the community, and one of them is that if a company offers a services to customers, and the company giving the services requires consent from the customer, and collect data from the customer. If the customer does not provide the consent, the company does not provide the services. So essentially, it's a refusal of services on the basis that the customer does not give its consent to provide its personal data. I think you see this a lot with banks. I'm not criticizing the banks, but it is a common practice. And the issue is, one provision in the new implementing regulation actually provides that the customer or the data subject has a fundamental right to refuse to provide the personal data. And if the customer or the data subject refuses, the company cannot not provide their services because the customer does not want to provide his personal data. So you can't, if going forward, the banks cannot say that if it wants to lend, one of the conditions for the lending is for you to sign forms where you relinquish your right or consent to your data being used by the banks. It cannot be a condition anymore, at least under the implementing regulation, if it's issued in that form. Another misconception is if the customer consents or provides consents, does that shift liability from the data controller, i.e. the company that manages the personal data? So for instance, if there's a data breach, can the company, if a terms of policy says that the customer accepts risks and liabilities and cannot sue the company for any data breach, is that enforceable? The answer is no. You cannot contract your liability out in that way. So the fact that the data subject or a customer provides their consent is not in evidence, or it does not exonerate, does not excuse the company from liability if there's a data breach that is at the company's fault. So that is another misconception that the company should be aware of. Another thing is, and this question comes up a lot, and there's the extraterritoriality of the regulation. Namely, does the regulation only apply in Indonesia? And typically the answer would be yes. But the PDP laws actually says that if, it also applies extraterritorially. Yeah, sorry for the word jumble there. So if an overseas entity conducts an act that has an effect on Indonesia or on people in Indonesia, then that company can be caught under the PDP law. So it has the extraterritorial effect. Another way that the extraterritorial provision applies is that it also applies to Indonesians that are currently overseas. And so those are ways the PDP law has extraterritorial reach. So yeah, just let me hand it over to you.
Thank you. Alvin, do you have anything to say on the misconceptions side of the regulation?
as a business person, DPO, you gotta get one. Okay? So like you were saying earlier on, whether or not it is a requirement, yes it is, right? How and what and all of that, yet to be seen, but you're gonna have to have one, because if you don't have one in house or any form of arrangement, you are not in compliant. The second point was not really misconception, but more of a comment. I mean, recently, about 3 or 4 weeks ago, BRI turned around and told lots and lots of people, your money's gone. So that ties it back to what I was saying. I'm not being critical of the government, yeah, but for this to work effectively, you got to be able to trust the government. So there was a big, reports and all of that, and then I tried to find what the aftermath is. I can't find anything. It's gone. It's like it never happened. So, yeah. So prepare yourself. Adopt best practices. Find a framework that works for you. There are many frameworks. Most of them are 80-90% the same. Whether or not you go with the American system, PDP, or whether you go with the European system, GDPR, it doesn't really matter, because at the core of it, most of it is the same. And protect what you can, and if anybody is looking to open a business, I think you can do an outsourced TPO business.
It's definitely a good business idea on high demand for the next 4 months. Thank you, gentlemen, for your time. I think it's very much high time to wrap up. So if I can conclude, a few things to watch out for, to see how this act is going to be implemented. Of course, recognizing what Petri said earlier on, that a lot of actors are part of this task force, so we need to watch out for that. We also need to, as Mr. Min mentioned, recognize that this issue is very much a reactive area and issue, and that recognizing that as the first step to being proactive, and pointing out to what Pak Nico said as well. Many stakeholders and many circumstances, and the way that regulation has been created and implemented in Indonesia, let's just say at the very least, is very dynamic, multifaceted. But also gives up hope, for people who, for business owners who perhaps are not large businesses, still under SME. There are steps that can be taken by them, which doesn't require massive amounts of initial investment, but just to prepare oneself to mitigate the risks that might be implicated by this new act and its implementation. Thank you, gentlemen, for your time. I'd like to actually open up the floor to any questions that the audience may have. Yes, please.
Thank you. First of all, thank you for all the panelists and the moderator for very insightful sharing and views. My name is Kiki. I'm from Standard Chartered Bank. Coincidentally, I'm the compliance advisory head and double heading as DPO right now. So please.
Heavy role.
Yeah. Especially after hearing what Pak Petri and Pak Min have been sharing. Now I'm getting worrier and worrier. Okay, so let me ask a few questions to actually just a little bit recovery to my worry. So the first one, I think I would like to address to Pak Nico, right? Because you mentioned the absence of clarity of regulations in a way can be a benefit, right? But I'm not being over prudent or over pessimistic, but I learned that when GDPR was actually enacted, firstly, right, one of the biggest threat is actually lawyers trying to. Sorry, I was also a lawyer, so no problem, right? So we're actually lawyers were trying to find, the loopholes, right, in implementations, and therefore it exposes entities into various legal claims, right? And I note also your statement that the absence of the implementing regulations actually would be something to prevent the government from imposing sanctions. But in one of the socialization in banking industry, where the Directorate of Information and Communication attended and presented the case, he mentioned that the law is effective ever since it was issued. The transition is only for your preparation of implementation. So right now, there has been legal case where the legal ground for the legal claim is this law. So I just would like to hear your thoughts on whether you think in the upcoming years, right, there will be, in Indonesia context, right, there will be this kind of trends also as per GDPR implementation back then in Indonesia, given that I think people are getting more and more, which is good, aware of data protection. That's one. Sorry, everyone. But I think it's a good learning for all of us. Okay, so for number two, I think it's still a little bit of legal matters, right? For consent, I think the basis for data processing in our PDP law compared to GDPR is just the same. There are three. There are more than just one category. There is more than consent, which is the legal contractual basis and also compliance to laws and regulatory enforcement. So I'm just asking whether in the draft of the implementing regulations, where it mentions that, as Pak Nico explained, that it will, for banks, it will not be possible for actually putting the clause there, but just a thought, right? In providing our services, especially for banks, we do need personal data. Otherwise, we cannot process and we cannot provide you financial services. For example, if I want to process a transfer, I will need your personal data. Because unfortunately, in BI regulation, in OJK regulation, for fund transfers, we need to get that personal information. The aim for that regulations are from financial crime perspective, while it's a little bit contradictory with the personal data protection. The aim from financial crime perspective regulation is to get as much information from your clients, is to know your clients, while for the privacy data, it's a need basis, right? Where it's actually quite contradictory. Right, so that's why I'm just wondering. I just want to get a confirmation that the basis of processing data for complying with laws and regulations in Indonesia, as well as financial contractual obligations of the bank, where I might not be able to perform my obligation to you if you don't provide me what I need, right? Are still respected. Because I see it being respected in the PDP law, but I'm just worrying when I heard from you that it might not be the same in the next implementing regulation. And the last one. Yeah, this one is for the DPO, right? Yeah. In Standard Chartered, fortunately, right? There have been GDPR implemented, right? And we have DPOs, but the more I hear it, actually, initially when I heard it in the first time, and also the more I hear it over the time, including your presentation today, Pak Min and Pak Fetri, about the role for DPO is very broad, and I think a legal and regulatory background only seems not sufficient. Because it seems that a cybersecurity technology needs to be the skill set. So I'm just wondering whether in your interactions with the government, or the Director General of Information, whether in the competence curriculum for the DPO that the government is now preparing, will there be any requirement for having these capabilities in more than just one aspect, right? Because the IAPP, we do have the CIPM, right? But it's more on the regulatory angle part, but not on the cyber or the technology part of it. So I kind of resonate what you mentioned, that a DPO should not be one person. Sorry, Bu Devi, my boss is here. Okay, so it's more it's more like a unit, right? Yeah, and for with the big responsibility of a DPO, do you see there is a legal, personal consequences that might be addressed the way it exists for personal liability of like a director of an entity? Because if that is the case, then we might need to think about protections that we need to put in place. Thank you.
Thank you. Would you like to start?
Yes, thank you, Ibu Kiki, and thank you for pointing out that lawyers are problems. But I suppose lawyers do take advantage of any opportunity in any situation. Okay, on your first question regarding the effectiveness of the law, yes. So when it says 2 years transition period, the law requires companies to implement them after 2 years. And so I think that's what it means. And I know certain government agencies say that the sanctions still apply regardless. It doesn't have to wait until 2 years. But I'm actually not sure whether or not there is any instance where a company has been found liable under the PDP law for a data breach. I'm not actually aware. And we're reaching the 2-year mark almost with no instance. I know there is data breach cases that have been brought to the courts, but I don't think those cases involve a breach of the PDP law. It's another law. But in any case, I do see that if a government or regulator or law enforcement seeking to enforce a law where there is no government regulation, I think that potentially creates legal problems for the enforcer themselves. I would still think that the 2 years period is still relevant. Now for banks, I understand that there is a separate OJK regulation that applies specifically to banks. And I understand that bankers are its own different creature, juga ibu, right? Just like lawyers, right? And so they are under there are special rules, specific legal frameworks for banks, and they are regulated by the financial regulators, by the OJK. And so there are regulations that apply to banks. Now, on your second question regarding the refusal of consent and the exchange for services if the consent is not given. Now that actually appears in the draft government regulation. I'm not sure, and we'll see if it manages to be in the final issued regulation. But the current regulation that I saw has that provision, that's correct. Now, but for banks, I understand the concern. You need the personal data in order to conduct the bank's business. The PDP law, interestingly, provides exceptions. And one of those exceptions applies to financial institutions or financial activities. So that may be the exception that banks can rely on in this regard. That is in the PDP law. It's one of the 5 exceptions that apply, that is given under the PDP law. I think that's the 2 questions that are addressed to me. So good, there's another third one, but in any case,
Okay, under the draft implementation regulation, there are 2 terms being used for DPO. Pejabat pelindung data pribadi and petugas pelindung data pribadi. So the petugas role is more the technical implementation role, and the pejabat role is more to do with the responsibility as a compliance or legal person that is closely linked to the level of the board of directors, basically, level of the board of directors. So in a sense that the government is now looking at whether this DPO position or DPO role can be limited in terms of responsibility. And another misconception by most of the companies here in Indonesia is as soon as they appoint a DPO, then that DPO is liable for any breach. So that's a misconception. The DPO cannot be taken to court if he or she done his work properly. The DPO is not responsible for the implementation of security controls related to privacy, but he is responsible to evaluate, to assess, and report to the directors on the level of compliance of that company in reference to the GDPR. Okay. So there's the implementation regulation is now trying to finalize on how best to form this DPO role within a big company, the difference between the pejabat and the petugas, and whether there are any issues related to allocating the technical role to units that is directly responsible for the implementation of security control. Whether the head of IT can be appointed as the petugas pelindung data pribadi, for instance, because he's also responsible for implementing the controls, or whether that has to be segregated or separated with an umbrella. So that's still being discussed.
Based on what Fitri said, in the past, whenever I was involved in developing cybersecurity department or squad or whatever we want to call it, it's always never one person. It's always, we would typically have minimum 2 or 3, and dotted line supported by the legal, in-house legal or in-house counsel. Because the legal individuals don't understand technology, right? A technology individual don't understand legal. So they need to sort of come between, and then that person in the middle kind of translate, like a business analyst, the internal. So the IT department, in-house IT department, will make policy, philosophies, and they will do the implementation, which a part of that is your how to handle data, right? And then because of the PDP and GDPR, we would always have a designated or dedicated resource to run it. But that person, like you said, is not legally liable, but the person is liable and not liable and responsible to report and you know, making sure that the philosophies and the policies are properly implemented. And then every now and then there will be addendum to the law and things like that. Then they will get together with the legal team to update each other and things like that. So I have never been in an environment where DPO is just one person. It's always minimum 2, and usually we will pair a very technically inclined person with a legal kind of experienced person. Yeah, that would be the way to go. Yeah.
All right, thank you. Unfortunately, we've run out of time, but don't worry. Thank you, Bukiki. I hope her comprehensive questions cover everybody's questions here today. But not to worry, if you do have any outstanding questions, we will have time at the very end for a networking session where you'll be able to interact with Pak Fetri, Mr. Min, and also Pak Nico directly. But yeah, that is all for me. Thank you so much, gentlemen, for your time today. And again, thank you to our partners, Jakarta Land, for providing the venue for this event, as well as Turkish Airlines as our annual partner. And thank you to you all for attending. I hope this session was useful to you and your areas of interest. And we really hope to be able to see you on our next event. Thank you, everybody. I'm going to hand it over to Tom, who I believe will be giving us some closing remarks on the event itself.
Yeah, first of all, I will be brief. I understand we've got, we're kind of running over time here. So thanks everyone for your time today and attending. Thank you particularly to our panelists and Chandra for for an engaging discussion around the PDP regulation, its implementation, obligations and risks. And looking around the room, I can see this is one of our better attended hub events, at least for the technology and digitization hub event so far this year. So again, thank you all for coming. As I say, in closing each one of these events, at least for the TnD hub, any member of BritCham, please request any topic or activity that's related to technology and digitalization. We'll probably be able to make it happen for you. So if you're curious, please just come up and let me know. And thanks again to all of you for being here. And for our panelists, we'll just take a quick photo, and I know Chandra has to run out the door. So thank you very much, everyone. Thanks for coming.
Saya harus pergi. I have to take his picture.
You guys want to come here, we'll just get a quick photo.
Yes.
Here you are. Thank you very much. We should do that, we will do that here. That's great. And one with everyone. It's Sean. That's really good. All right. Thanks, guys. Thank you very much.